The Gislason and Hunter Estate Planning Practice Group assists clients in all aspects of estate planning. There are several milestones in your life in which an estate plan should be reviewed.
People often ask us, when is a good time to do a will? The answer is probably sooner than you think. And also you need to consider the times that you need to update your will and your estate planning documents. We like to think of that process as looking at the milestone events in a person's life. And at certain milestone events is a good time to pull out your will and look at whether it needs to be updated and whether your other estate planning documents need an update too.
Estate planning can start as early as at the age of 18. Now, very few teenagers need wills at that age because very few teenagers have enough assets for it to economically make sense. However, it isn't too early to execute a healthcare directive. A healthcare directive allows a teenager to designate who should make decisions for him or her if they are unable to make those healthcare decisions for themselves.
Estate planning is especially important if you're starting your own business with one or more partners or co-owners. Corporate governance documents like buy-sell agreements, member control agreements, or other governance documents can help you plan for the business if something happens to you.
Getting married. A will is a great, though not very romantic wedding gift. However, this is also a good time to review how property you and your spouse own is titled, as well as beneficiary designations of insurance policies and pensions. Making a major property purchase is a wise time to update your will.
The birth of a child is an important time to update your will. Young couples may think they need a will because if both spouses die, they assume their children will automatically inherit everything. Even if that is the case in your particular situation, and it may not be, the law really doesn't have a default for determining who raises children and takes care of their money if something should happen to both parents. Naming a guardian, custodian, and/or trustee in your will is one of the best ways to make sure that if something happens to you, your children's future is stable and secure.
One reason that you might need to redo your estate plan, such as your will, when you receive an inheritance is because it may affect your estate tax and how your estate is treated, both at the federal level, because remember there's both a federal estate tax and Minnesota estate tax. And so you need to deal with both of those separately. And how many assets you have, how much assets you have, will be impacted by how the size of your estate and how those taxes apply. So if you receive an inheritance and all of a sudden your estate, the amount of your estate goes from something that's, let's say, relatively low to something that's maybe significantly higher, that would be a time that you would need to have your will looked at, see what the estate tax laws are that are in effect at the time, and make some adjustments to your will possibly to deal with those, manage those potential estate taxes.
Separation or divorce. The last thing you probably want to do when you're going through the stress of a divorce is add yet another legal issue to your plate. But consider, do you really want your soon-to-be ex-spouse to inherit all of your property if something should happen to you before the divorce is finalized? If you've already been through a divorce, it's time to update your will to reflect major changes to your family's needs. Talk to your family law attorney about when the best time to do estate planning is in your particular situation.
If you move to another state, you may want to consider doing a new will. You don't need to because most or all of the states in the United States have adopted what's known as a Uniform Probate Code, which means that a will that you've written in any state should be honored and followed by the laws of any other state. But if you do move, there are other reasons why you may want to consider doing a new will. For instance, there are local laws that will apply to the probate process, and your will may need to be adapted so that it can adjust to whatever those laws are. Another reason might be if you have some means of wealth and are subject to estate taxes, that you would want to adapt your will to the state taxes of the state where you've moved to. Another reason, for instance, might be that if you have small children, you want to make sure that the right people are going to take care of them in the right place, that you're doing that locally under the local probate laws.
Subsequent marriage. Wills and other estate planning devices are vitally important for blended families. Depending on you and your spouse's family situations and individual property, anything from step-parent adoption to special trusts or life estates to split inheritance between your new spouse and your children may be in order. Long-term committed relationship. Wills, powers of attorney, and healthcare directives are also vitally important to couples in long-term committed relationships but who are not married to one another. Inheritance laws are not equipped to determine how close a relationship between two unmarried people is unless you've made it clear in your estate planning.
A good time to update your will is on the birth of your first grandchild, or any other grandchildren for that matter. You could provide educational benefits for them. You can make sure that they're included in their will, especially if their parent should predecease them. And you might want to set up a trust because they're going to be young by the time they might inherit from you. Another good time to update your will is on the death of a spouse. You normally have many provisions in your will that include your spouse that are no longer going to be relevant. So you want to make sure that the will is updated to keep it current with your intentions.
Poor health, lasting illness. Don't wait this long to get a will, power of attorney, and healthcare directive. Though an attorney may be able to put basic documents together for you quickly, this ideally should be a time to just review your already in place estate documents to provide you with peace of mind and perhaps make a few minor changes. The key to estate planning is to plan. Gislason and Hunter estate planning attorneys are available to assist you in all of your estate planning needs.